Welcome to Crime Before Modern Law. Here, we explore how crime and justice functioned before modern policing. If you find this topic interesting, feel free to leave a comment telling us where you are watching from. And if you would like to support the channel, a like or subscription always helps. For most of human history, there was no police department, no 911 system, and no professional detective squad. Yet communities still tried to find offenders, prove what happened, and enforce punishment. They did it with tools that look strange today: public shouting, group responsibility, sworn oaths, local courts, and officials whose job was only partly about crime. This documentary explains how crimes were investigated before modern police. The details changed from place to place, but many societies relied on the same basic idea. Investigation was a community duty, and the court system expected ordinary people to bring information forward. First, it helps to define what investigation meant in a world without police. Today, we often imagine investigation as a trained team collecting evidence, interviewing witnesses, and building a case for prosecutors. Before police, investigation was usually simpler and more public. It focused on 4 questions. 1. Who saw the act happen? 2. If no one saw it, who can swear to someone is character or likely guilt? 3. Who in the community is responsible for producing the suspect or paying a penalty if they fail? 4. Which local official can hold a hearing, record the claim, and send the case to a higher court? Because these systems depended on people who were not full-time professionals, many investigations were fast, local, and driven by the victim. If someone stole your property, you often had to take the lead. If someone was killed, neighbors and local officials might act quickly, but they still relied on local knowledge instead of specialized detective work. A major feature of pre-police investigation was that catching and proving were not the same step. Catching a suspect could depend on pursuit and public cooperation. Proving a case could depend on oaths, community reputation, or local juries that already knew the people involved. Now we can look at the main methods societies used. Method 1: immediate pursuit and public alarm. In many places, the most important investigation happened in the first minutes after a crime. If a thief ran, the goal was to catch them while the trail was fresh. Medieval and early modern England is one of the clearest examples. When a felony was witnessed, the law expected ordinary people to raise a hue and cry, meaning an outcry that summoned neighbors to chase the suspect. The idea was simple: you did not wait for officials. You created a moving search party in real time. This approach worked best for crimes committed in public or discovered quickly. It was not good at solving crimes discovered days later, especially if the offender had left the area. A key point is that the pursuit was not optional. Communities were expected to help, and the failure to pursue could lead to fines or blame. In practice, this created pressure to act. But it could also lead to mistakes, false accusations, and suspicion aimed at outsiders. Method 2: group responsibility and produce the suspect systems. Many societies treated public order as a shared responsibility. Instead of building a professional police force, governments made local groups financially or legally responsible for the behavior of their members. In medieval England, one important system was franked pledge, organized around groups sometimes described as tithings. The core principle was joint surety. If someone in your group was suspected, the group had a duty to bring him forward. If the person fled, the group could be fined. This changed the logic of investigation. The question was not only who did it, but also which group must answer for this person. That encouraged people to watch each other, report problems early, and avoid sheltering offenders. Other parts of the world built similar systems. In Imperial China, versions of collective responsibility appeared in different eras, including the Baojiao system, which organized households into groups with local leaders responsible for order, records, and reporting. In such systems, information flowed upward through community heads. The investigation was often the work of local leaders, identifying who likely did it, who had a motive, and which household group should be questioned. These systems were not gentle. When responsibility is collective, pressure falls on families and neighbors. It can improve reporting, but it can also lead to forced confessions, scapegoating, and punishment of people who did not commit the act. Method 3. The victim as investigator and prosecutor. Before modern policing and public prosecution, victims often had to push a case forward. That meant reporting the crime to local officials or courts, gathering witnesses, identifying stolen property, paying fees and spending time, bringing the accused to court if possible. This is sometimes called private prosecution. It made investigation uneven. Wealthy victims could spend more time and money. Poor victims could struggle to bring a case at all. Because of this, many communities developed semi-professional helpers. In early modern England, thief-takers operated for rewards and fees. They were not police in the modern sense. They were private individuals who looked for suspects, recovered goods, and helped bring cases to court. This filled a real need, but it also created corruption risks. If a person gets paid per conviction or per recovered item, they may target easy suspects, threaten people, or even coordinate with criminals. Governments tried different ways to control this problem over time. Method 4. Local officials with part-time law duties. Even without police, many societies had officials who handled pieces of law enforcement. In medieval and early modern England, the constable was often a local, unpaid, part-time role. Constables could organize the watch, help keep order, and bring offenders before justices. Watchmen guarded gates, patrolled at night in some places, and reported trouble. These officials were not detectives. They usually did not gather evidence the way modern investigators do. Their role was to organize community action, make arrests in straightforward situations, and connect local events to the courts. As English legal administration changed, offices like the Justice of the Peace became central. Justices could examine suspects, take statements, and decide whether to send a case onward. In cities and empires, the division of labor could be more advanced. In ancient Rome, public order in the city involved a mix of magistrates and specialized forces. The vigils are often remembered as firefighters and night watchmen, but they also had responsibilities related to nighttime security and certain offenses. Rome's system still was not modern detective policing, but it shows how dense urban life pushed states to create more organized responses. Method 5. Inquests, inquiries, and early fact-finding hearings. A major problem in pre-police societies was establishing basic facts when violence occurred, especially in suspicious deaths. In medieval England, the office of coroner developed as a way for the crown to ensure that certain deaths and pleas were properly recorded, and that royal financial interests were protected. Coroners could hold inquests, using local juries to answer questions about how someone died. The jury here was not like a modern trial jury selected from strangers. It often consisted of local men expected to know the area and provide informed answers. This is a different model of investigation. Instead of detectives gathering evidence and then presenting it, the system asked a local body to state what it believed happened, based on observation, rumor, and community knowledge. The strength of this approach was speed and local familiarity. The weakness was bias. If the community disliked the victim or the suspect, knowledge could become prejudice. Method 6. Presentment and community reporting to courts. Many medieval and early modern courts relied on presentment, meaning that local juries or community groups reported suspected offences to a court. In England, manorial courts and courts leet could handle small offences and local order. They used juries that presented wrongs and offenders. This was not a police investigation. It was a governance system in which the community itself was expected to bring forward information. Presentment worked best for ongoing visible problems, repeated nuisance offences, market cheating, assaults in a small village, or disputes that everyone already knew about. Method 7. Oaths, reputation, and proof without physical evidence. Modern viewers often expect forensic proof, fingerprints, DNA, surveillance video. Before police and modern science, proof often meant sworn statements. In early English law, compurgation, also called wager of law, allowed a party to support their claim by bringing oath helpers who swore to the person's truthfulness. The oath helpers did not have to know the facts. Their role was to vouch for credibility. This reveals something essential about investigation. Before modern policing, social reputation could function as evidence. If the community trusted you, the law was more likely to accept your denial or your accusation. If your reputation was bad, fewer people would risk swearing for you. This could discourage habitual offenders, but it also punished outsiders and the poor. It also shows why records, registration, and stable communities mattered. The system depended on knowing who people were. In some earlier European contexts, proof could also involve ordeals, which were religiously framed tests meant to reveal truth. Over time, many legal systems moved away from ordeals and toward other forms of proof, including more formal witness testimony and jury verdicts. Method 8. Market regulation and public order officials. Not all law enforcement was about murder and theft. Much of daily order involved markets, weights, prices, sanitation, and public behavior. In many medieval Islamic cities, the muhtasib is often described as a market inspector and supervisor of public conduct. This role shows how investigation could focus on inspection rather than solving mysteries. The official might check scales, investigate complaints about fraud, and punish violations on the spot or bring them to a judge. This model is closer to regulation and detective work. It works when offenses are frequent and visible, like cheating customers. It is less useful for hidden crimes, like secret theft networks. Method 9. Rewards, wanted notices, and early information networks. Without police stations, governments and communities still built information networks. Rewards for capturing offenders encouraged action by private citizens. Notices posted in public places, and later printed in newspapers, spread descriptions of suspects and stolen goods. In 18th century London, the Bow Street magistrates developed a more organized group of officers, later known as the Bow Street Runners. They were connected to a court and funded in part by government support. They did not patrol like modern police, but they pursued suspects, served warrants, and traveled to make arrests. This period is important because it shows the transition from informal community action and private thief-takers toward a more regularized, semi-professional approach. What investigations usually look like in practice. Across these systems, a typical investigation had a pattern. First, discovery and alarm. A victim notices loss or harm. If the offender is nearby or fleeing, people chase, block roads, or alert neighboring communities. Second, identification by people, not by objects. Suspects are identified by recognition, rumor, prior disputes, or patterns known locally. Third, recovery and confrontation. Stolen goods might be tracked through markets, pawnbrokers, or neighbors. Many cases depended on finding property rather than proving complex chains of events. Fourth, local hearing. A local official, court, or inquest gathers statements, hears accusations, and decides whether the matter is serious enough for higher courts. Fifth, proof by oath, witness, or community verdict. Instead of forensic evidence, the case turns on who is believed. Sixth, enforcement. Punishment might depend on the local court, the Lord's authority, the sheriff's power, or later, more centralized courts. Strengths of paperless investigation. It is easy to focus only on the weaknesses, but these systems had real strengths. Speed. When communities were required to act immediately, suspects could be caught quickly. Local knowledge. Neighbors often knew disputes, reputations, and patterns of behavior. Low cost to the state. Governments could maintain order without paying large standing forces. Social pressure. Collective responsibility created incentives to prevent crime and to report offenders. Limits and risks. At the same time, these systems had serious limits. Bias and exclusion. Outsiders, minorities, and the poor could be suspected more easily. Unequal access. Victim-led prosecution favored those with resources. Corruption incentives, rewards, and private enforcement encouraged false accusations and cooperation with criminals. Weak capacity for complex cases. Organized theft rings, long-distance crimes, and hidden violence were hard to solve. Low standardization. Procedures varied by region and by local power structures. Violence and coercion. In some systems, confession or community pressure could replace careful fact-finding. Why modern police and detectives eventually developed modern policing did not appear because earlier societies had no order. It developed because older methods struggled with growing cities, mobility, and economic complexity. When populations expanded, people no longer knew their neighbors. Reputation became harder to measure. When travel increased, offenders could escape local responsibility systems. When markets grew, stolen goods moved farther and faster. And when governments became more centralized, they wanted more consistent control over law enforcement. The path was gradual. Watchmen and constables became more regular. Courts developed better record keeping. Governments funded specialized officers. Newspapers spread descriptions. Professional forces emerged, and eventually, detectives formed as a separate function. But the earlier world should not be seen as a simple before and after. Many older methods survived alongside new ones for centuries. Even after professional police appeared, communities still relied on public reporting, witness cooperation, and local knowledge. Key takeaway: before police, investigation was usually not a secret technical process. It was a public social process built around immediate pursuit, group responsibility, local officials, and courts that relied on community knowledge and sworn statements. Understanding these systems helps explain why older laws often focused on duties to raise alarm, join pursuit, present suspects, and swear oaths. Those were the tools societies used to find truth and enforce order long before modern law enforcement existed.